they were to get us
This is a quote
started.
we got from somebody who's saying,
You know, Senator
when does one realize
You
that
can just have Mark come up, yeah. And Floyd will join us.
you won't work?
So we're on the record.
We on the record?
Thanks for joining us for the April 27th meeting of the Joint Committee to Implement Measure 91. We're just getting started, and we very much appreciate your being here tonight. Tonight we're at an interesting moment in our work. We have, after having a number of public hearings at which we've received a lot of great input from people in the community, including growers and processors and dispensary owners and patients and people who want to get involved with this industry, we've come up with the Dash 6 amendments to Senate Bill 844, which are a very significant movement from where we started up. As those of you in the room who've been with us from the get-go will recall, we're quite a bit evolved from the point where we started, and that reflects great input that we have received from you and others in Oregon who've given us their views and concerns and needs. And today we are in a work session on Senate Bill 844-6, and we're going to start by inviting testimony from Senator Prozanski, Vice Chair of this Joint Committee, and Mr. Mark Mayer, who's done some tremendous work putting in amendments and ideas and changes. And then we're going to have Shannon O'Fallon, who is an attorney with the Department of Justice, available for questions and as a technical resource as we need her. But our goal tonight is to have the members of this committee really talk about where the draft is, answer any questions that we have, and make sure that we all understand the bill terms. Everything in this bill, as I'm sure you are aware if you've taken a close look at it, every major concept has been vetted and gotten careful feedback in one form or another over the course of the last many weeks that we've been coming together. So some of the configurations may be new to you, but the ideas, grow limits, residency requirements, tracking systems, what kinds of registration, who's in charge, all those things are things that we as a community have been talking through for many weeks. And now we will hear from Senator Prozanski and Mr. Mayer about the elements of this latest draft. Thank you, gentlemen, for all your hard work, and it's good to see you tonight.
Thank you, Madam Co-Chair. Floyd Prozanski, State Senator, District 4, parts of Lane and Douglas counties. And sitting next to me is the guru of all drafters, Mark Mayer. And I'm not sure how the co-chairs want to go forward. I thought that Mr. Mayer was going to kind of go through, and I was going to maybe give some color on the play-by-play.
Madam Chair?
Yes, ma'am.
I actually asked Senator Prozanski to do this on behalf of our group that put this together, and that was to, on matters of policy, to be the spokesperson for us on the matters of policy, and then Mr. Mayer can handle the technical things, unless you want to do it all.
I personally do not. What I'll say is that for those who are listening and all that, the group that was meeting were the two co-chairs, myself and Representative Buckley. And basically what we were attempting to do is clarify in the existing statutes on the medical marijuana and making changes from where we have been in the past to where we are needing to go in the future, and specifically changing some of the terms and definitions to clarify that we're trying to move away from some of the terminology that was used before. And you'll see in section 1 that we go into what the definitions are, and you'll see, and then we call out as to what some of the different processes are, how that is actually accomplished, and such. Getting beyond section 1 and into section 2, we are going into really existing language on the statutes as to the registry, identification card holders, and designation of primary caregivers. And what Mr. Mayor has done is taken the language as it was in statute, has basically clarified that. And so if you look on page 12 of the draft on the -6, you will see after what was existing law has been basically taken out, and the new transition of what that section will include is in bold print starting on line 14. Going through this process, we're also looking at on page 17, section 5, gives you the introduction to the medical marijuana producers. Again, this is taking and clarifying language that has already been there, but has been rewritten to give it more of a term of art as to where we're at today in the configuration of what we are wanting to identify and the terminology that we want to use. There is one part I guess I would call out on page 20, lines 10, does in fact talk about some of the issues that we've talked about as a committee as to the length of residency for an individual to be able to be in the capacity of a producer, meaning someone that's actually would be growing marijuana. And so then the other, I think, worth calling out is on page 22, line 6, sub 8, actually gives a perspective of where a grower will be able to be compensated for all of their costs associated with the production of marijuana, which includes their actual time, their labor.
Madam Chair,
Yes.
that's just a minor correction, just adding labor, but because everything else was already included, wasn't it?
Pretty much. It's not, it's a significant, we are basically, what we're attempting to do here is we're trying to ensure that the medical marijuana program stays intact, looking and gearing as to what might happen with a recreational sale. And one of the ways to ensure that individuals that are currently participating in that program, that they would be able to be compensated fairly.
Time as well as their material and, yeah.
Senator Cruz, that's correct. And also what we're looking at is in the sense of knowing that one of the key issues that this committee has been tasked with is how to deal with the, let's say, the surplus of product that is not making it into the hands of the cardholder or to the dispensaries for sale within the program, but has been documented, at least from what we've been told through law enforcement, to actually making its way into the black market outside of the state and elsewhere. And so those are concerns under the Cole memorandum that we need to be addressing to ensure that. And so one of the things that we're figuring is that if you can actually ensure that individuals that are in this processing or production are actually being compensated for their work, that will also help curb the impact on the stuff going into the underground market.
May I jump in for a second? You know what I think would be helpful is if and Senator Przanski, you're doing a hero's job of giving us, kind of a lawyer's walkthrough. I think it would be wonderful if, Mr. Mayor, if you would be open to giving us a kind of a broad overview of what this 844-6 does, because this is our opportunity as a committee to talk about the key categories of things like, how we're going to be handling registration and tracking, the plant count decisions that we have come to, residency issues, lab standards and testing, some of those key issues, ideally in order of roughly how they appear in the bill. And then committee members, if you have concerns or questions or you want to hear more about an issue, please jump in. Senator Przanski, if there's a policy decision that is really embedded in why we came to that amount, please jump in. I imagine that Mr. Mayor may be a little reluctant to attribute motive or reasoning to us, but I know that you'll be able to feel comfortable speaking of those things. So how would that work?
Madam Co-Chair, what we'll do...
Senator Byer, I'm sorry, sir.
Can we ask questions?
Sure, you want to start with the question now? And then I think
What-
Mr. Mayor may walk through.
Yeah, I think that's what I thought was the task you wanted. I'm
Yes.
more than glad to have Mark go through that, and I will give the color. And we will go through, I think it's easier to go from page 1
Yes.
through on the section, so people who are following will not be bouncing around, because there's some other parts that are interrelated. As Mr. Mayor says, one of the things is a personal agreement, which we'll go over when we get to it, as to how that plays in with the growers and how we can give protections to them, et cetera.
I think that's right. So Senator Byer, are you comfortable with that?
I can wait.
Okay, great. All right, Mr. Mayor, please kick us off. Thank you so much, both of you, for your work.
Chair Leininger, Chair Burdick, Mark Mayer, Legislative Council. Senator Przanski's done a really good job of walking us through the first sections of the bill up through the producer section, and he's correct. We have updated the language as well as included language referencing the processors throughout all these sections, which is a piece that we'll look at later. I think he left off on subsection 8, which is that subsection 8 of section 5, that all costs attributable to the labor associated with production of marijuana can be compensated for underneath this draft. It does include labor, and I believe in the original statute as well. We fold utilities into this particular draft now as well, which I don't think were part of the original statute. So we've done that. There is some increased authority for OHA to inspect designated grow sites underneath this section. That's subsection 9. And if you move down to section 6, that's where we get into probably what's the first real major policy deviation from the original Medical Marijuana Act, which is the tracking light. Underneath this draft in section 6, producers will be required to monthly report on basically what they have in stock and at what process it is in stock. So if you look at the top of page 23, monthly they're going to report on the number of mature and immature plants and the amount of usable marijuana that they have in their possession, as well as the amount of marijuana leaves and flowers that are being dried, so what's in process of being turned into usable marijuana. And then throughout the rest of those paragraphs, we're looking at the number of plants and usable marijuana that's being transferred to various sources. And that's going to be a monthly report that is sent into OHA.
Let me just go ahead and throw in that I think one of the key points in the definitions is the definition changing of immature versus mature plants. A mature plant will be one that is flowering. An immature plant will be one that's not flowering. So we will not have the 12 by 12 inch type of configuration to determine this, whether the plant is mature or not, but instead we'll rely exclusively on it being to the point of where it's flowering.
Great.
Section 6A is merely a applicability clause. Section 7 is the grow site possession limits section of the bill, and this has changed quite a bit from the previous statute. There's a lot of policy decisions that were made in this particular section. So just as in the current law, a registry identification card holder or a patient, their caregiver, they can jointly possess 6 or fewer mature marijuana plants. And then a person designated to produce marijuana under 475-304, they can produce for 4 registry identification card holders. That maintains the status quo. What we have written into the statute is specific cap limits on plants that will be allowed at addresses. And this is to basically set a limit regardless of how many marijuana grow sites are co-located at an address. It's to set a limit of the plants at those particular addresses. If it's located within city limits in an area zoned for residential use under sub 3, for people entering in the system on the operative date of this bill forward, or excuse me, from January 1st, 2015 forward, then there will be the cap will be 12 plants in a residential area in city limits. Other than that, underneath this bill, the cap amount will be we are grandfathering in for residential urban 24 plants. So if you're registered with OHA prior to the enactment or the effective date of Measure 91, that is the plant cap, which is 24. We have the same standard for non-residential urban areas. 48 is the cap overall for those areas. However, if you have grandfather status, if you're registered with OHA prior to January 1, 2015, the cap is going to be 96. The cap may also be limited by the amount that you first report. So if you first report 90 or something like that, then that will also hold. What you have in your possession at the time that you first report.
Let me just throw one other thing out, because I know this is an area that was a lot of concern. What we currently have in law, what the law is today, is going to stay in place until this actually has the effective date going in place. You'll hear later that it will be considered at this point in March of 2016. I think there will be some other discussions as to that date, whether that's an appropriate date. But I think for those who are here, this is not something that just happens overnight. This is something that transitions into an effect, and so you will continue to have individuals that are, what they're doing today will not be prohibited until the effective date of this legislation.
Yeah, the legislation will not affect the current grow season underneath this statute. We have on page 27, for those who have been grandfathered in, if you're a bad actor and your activities are suspended or revoked by OHA, then you lose your grandfather status. That's subsection 5. For grow sites that are not in urban residential areas, we have subsection 6, which is, I'm going to just loosely call it the ratchet down section, which if you lose patients, they decide to no longer designate you as your grower, those patients, you cannot be redesignated by another patient until you're down to the 48 limit. So those are the provisions of the grow site statute. I think that there's probably, is there legal questions here? I can take those now, or policy questions. Senator Brzezinski can take them, because this is probably a major component of the bill.
Madam Chair?
Yes.
Yeah, just to be clear on the grandfathering, if someone has a certain amount of plants on January 1st, 2015, and it's more than 48, that number will be grandfathered in up to 96. In other words, not more than 96 can be grandfathered in. But if someone has, 75, 80 plants, but it doesn't say that if someone has a grow before January 1st, 2015, they can't suddenly plant 96 plants. It has to be what they had at that time. Is that correct?
Chair Burdick, we tied it in as close as we could to that. That is the intent of the bill. There is a first reporting requirement, and they're going to be tied into that first reporting requirement. So, yes.
Madam Chair, I was just wondering about the migratory marijuana plants that this will incent, since some of them are planted in plastic buckets, and if you do a head count and come up with 92, where those other 2 plants are going to come, or 4 plants are going to come from, and I just thought they might migrate from somewhere, so that your first reporting would show 96. Anything prevent that? Or is it the honor system?
Because the bill will not, these sections will not become operative until March 1st, 2016, then that would be possible in the interim, correct?
Yeah. So, Madam Chair, I guess I was thinking that 96 would be a coincident number with the actual number that will be reported.
Okay.
So they can all be grandfathered.
But they still have to have cards to justify all the plants.
At this point, they do have to have cards to establish whatever their grow is.
By 2016, Madam Chair?
No, they have them now. If they're growing now, they have to be under the card system. That's what the card stacking that we heard about. And so that's what they'd have to be relying on. That would be the cross-check for this. The other thing that if you speak to many of the individuals involved in the growing perspective, the reason they've chose 96 is because they want to be under 100 because of the federal definition of commercial grow operations. So it's already one that has already been true and tested by those individuals to stay within the compliance of what they are concerned with the federal intervention.
So I have Senator Cruz has a question. Did you have a follow-up first?
Yeah,
Okay.
just a clarification. I mean, we got two sets of numbers here. One is urban, and the other is anywhere else. Correct?
Urban defining meaning within the city limits.
Yeah.
Yes.
Yeah. But the other limits are whether it's industrial, or ag, forest, whatever. Correct?
That is correct.
Okay.
So it could
Just-
be.
yeah.
Yeah. So it could be within. Yeah. Remember the ratcheting back was the part about the residential that many
Right.
of your constituents and ours have wanted some address.
Right.
Representative Buckley.
Thank you, Madam Co-Chair. I think it's important to kind of keep the kind of larger frame, as Senator Brzezinski was just mentioning. We're trying to balance the concerns of neighbors who have been impacted by growing operations in their neighborhoods with the, I believe, fully shared goal of making sure that no patient loses access to the medicine that they deserve and they require. The idea for grandfathering in growers was to make sure that the grower-patient relationships that existed at the time of Measure 91 passing and exist now, are, as of January 1st, 2015, are kept in place. And over time, we get to limits that can be, I think, easily understood by growers, easily understood by law enforcement, easily understood by fellow citizens of a certain area, so they understand what the expectations are. And we will also be discussing further on in terms of the tools that cities have in terms of time, place, and manner and nuisance. So we're trying to find that balance between making sure that no one who's in the program now is negatively impacted, but we all are also addressing the legitimate concerns raised by communities who have experienced impacts on their neighborhoods that they have concerns over. Thank you, Madam Chair.
Thank you. And to clarify for anyone who has not had a chance to look carefully at the language, I believe that the limits on urban apply to urban residential zones. So if it's a commercial zone or an industrial zone, it's not constrained by the 24 plant limit. That's for essentially neighborhoods.
That's correct.
Thank you. Please go ahead.
Co-Chair Leininger, that's correct. The exact language is within city limits, so zoned for residential use.
The zone for residential use is
Right.
key there, yeah. Thank you.
Are there any other questions on the production limits section? On page 28, Senator Brzezinski mentioned this a little bit earlier. The personal agreements, there's a tie-in with the producer language earlier, where currently under statute, all marijuana produced for a cardholder or a patient, it belongs to the cardholder or the patient. What we've done is we've allowed the grower and the patient to enter into personal agreements, if they choose to do so, to redefine the relationship that they have. This is not a mandatory thing. It's not something that can be done unilaterally by one party. It is something that both parties have to agree to if they choose to redefine their relationship, and that's what Section 9 is. So it doesn't actually change the fundamental structure of the law, but it does give an allowance to redefine that grower-patient relationship if desired.
And just the reason this is being, let's say, called out is because we'd heard that these type of arrangements have actually been ongoing through contractual agreements, and we felt that it was worth calling it out, that is permissible, but it's not required.
Great.
That is going on. So yeah.
Section 9A is primarily a lot of cleanup, and we're removing from statute some stuff that is no longer pertinent, giving the new definitions and stuff like that. However, we are rewriting the section. It basically says that if you are off premises and you have usable marijuana or you're moving mature marijuana plants with you, this was underneath the existing law as well, you need to have your card with you to prove that you are a lawful possessor of it. So that is that section. Section 10 is a major section in the bill. This was a section where we wrote into the bill medical marijuana processors in an attempt to create more regulation for the processors, and we modeled it somewhat after Measure 91. The statute and the language of Section 10 is loosely based off the dispensary statute, although we removed from that language certain things that didn't make sense for processors. I can go into that in a bit more detail if you'd like. But the idea here is if you're going to be making extracts, which are the combustible products that need to be made underneath high pressure, or if you're going to be selling into the dispensary system, then you should be registered as a processor. And you should be, because your products are going to be, they're going to be for mass consumption or on the grounds that it's dangerous, then that's what this does, is it basically regulates those people at a higher standard than what is currently allowed under OMMA.
Yes, Representative Buckley, and then Representative Helm.
Thank you, Madam Co-Chair. Mark, just to clarify that, so if I am a patient and I am processing product in a way that is safe, as defined by the legislation, and Representative Olson is also a patient, this would not restrict me from sharing what I have processed with my fellow patient.
That is correct, Representative Buckley.
So long as you're not charging Representative Olson for that product.
Right.
I wouldn't want any, though.
Just an offer.
Hey, it's good stuff.
Representative Helm.
Thank you, Madam Chair. On page 30, I had a question about where the processor can be located vis-a-vis a grow site. We visited, when we were doing our field trips, we visited at least one location where the grow site and a processor were located in the same building in an industrial area. And I think at the time I felt like that was fine. And so I wondered, just thought I'd ask you what the thinking is behind this limitation.
Co-Chair Leininger, Co-Chair Burdick, Representative Helm, we have received, or there has been feedback on that provision. What I would say about that is if you choose to address that issue at a later time, it can be very easily lifted from this bill through an amendment process in another bill. When we were working on this particular bill, we changed direction with the processing language quite a bit toward the end, and there wasn't enough time to actually go through and consider every single thing that we wanted to, every single small issue, and I think that that is one that just did not get addressed. And I'll put that on me, too, as the drafter. I did not raise the issue.
Chair Burdick.
Madam Chair, yes, I'm glad you brought that up because it's been brought to my attention as well, and I think it's something that we need to address in the other bill that we're going to be working on.
Thank you.
And for people who are hearing this and wondering what we're referring to, this committee anticipates having probably a couple bills. A bill that relates to the medical marijuana program, and then a subsequent bill that relates to implementation of Measure 91. It's possible, and in fact, we anticipate it's likely that there may be some tweaks, particularly technical things, or if there was an inadvertent omission from this draft, that we could add to the Measure 91 bill that would kind of retrofit this. So we've got a game plan for taking care of some of those things that we notice along the way, and this is one of them.
And Madam Co-Chair, I think as we go through those, we'll be flagging them, and we'll see what we can do in the sense of actually maybe getting them into what we have so it's consistent instead of waiting, because I think that would give a lot of individuals a lot more comfort knowing that it has actually been addressed on the front end and not waiting for the next round.
That sounds good. But in any event, our intentions are roughly those. Yes, please proceed.
If you turn to page 32, section 11 allows the health authority to establish standards related to processing by rule. And this is fairly broad rulemaking authority for public health and safety reasons. If you flip the page to page 33, section 12.
Before we leave 11,
Yes.
if we could,
Yep.
I have question about the involvement of the Department of Ag in this thing. I think to a degree, especially for the processing, I would suggest we take a hard look at having the Health Department do the inspections and have the oversight, because quite simply, the division right now in law between a kitchen being inspected by the Department of Ag and the Health Department is whether people can sit down and eat in conjunction with the kitchen. And I would suggest that what's going on in these processing facilities is probably slightly more complicated than making a carrot cake. Okay? And, I mean, at my market, we have a kitchen. It's inspected by Department of Ag. All I'd have to do is put in 3 tables, and it'd be Health Department. So I would suggest the expertise in the Health Department and the oversight is probably at a more technical level, and we might want to consider making that move.
That's a great point. I know there is some reference to the Department of Agriculture. Could you speak to how we envision them working together now? And I think we might want to amplify it. It's good input.
Co-Chair Leininger, Co-Chair Burdick, Senator Cruz. So we've only called out agriculture for purposes of OR 616-695 to 616-755, which is sanitation standards.
Right.
So we've called them out there. Further down in the draft, you'll see underneath the general powers section, we have used language that's very similar to what's in Measure 91 about OHA being able to request assistance from Ag as well as OLCC for purposes related to implementing the Act, to give them the freedom, as they have in 91, to basically share duties. So some of that might be able to be handled through a memorandum of understanding as well, depending on how the agencies sort out what is the most appropriate agency to handle that type of processing or production.
Okay. I guess it's an issue I've had big picture for a long time. You have a nursing home and you have 5 different agencies going in to do different inspections, looking at the same thing, just adding cost and cost and cost. And so the simpler we can make this, and kind of, I'm looking at one-stop shopping, and because the Health Department is both on the testing and the inspection and the certification, they are the primo folks there. I would suggest, because we can do that if we choose to, I would suggest we take a look at doing that.
Okay, thank you.
And I'm just going to go ahead and call out also on page 32, in my quick review of the most recent draft compared to the working copy, there's a question as to maybe some language that might have got picked up that wasn't in one of our original ones, which is lines 4 through 6, and I'll mark that for looking at later.
So that for potential omission.
Yeah, I think that was included in here, where I don't remember it being in another draft, and one of the concerns there is that the cost of that type of
Right.
process is going to drive the cost of the product.
Thank you. Good. All right. Keep going.
So again, on page 33, if you flip, we have the tracking light for the processors. And again, this section basically gives OHA rulemaking authority for the processing of the different types of products and for the transference of these products to different recipients, including the dispensaries. How much is being made, as well as how much is leaving shop and going to various recipients. So that's what we have in section 12.
Great. Thank you. Representative Helm has a question.
Thank you, Madam Co-Chair. My only question here with Section 12 is why it's a may instead of a shall.
I did the same thing with the dispensary statute on that end, and I wanted to give OHA as broad authority as possible to implement the tracking as they saw fit. So I'm actually not sure how fast they can get up and running the tracking system. It could easily be changed, though, if that was the direction the committee wanted to take.
Follow up?
Yes, please.
It just seems to me that this is the kind of information that we've been wanting to get at as a committee and in our questioning, and I think we should give a hard look to requiring them to do that rather than just
Okay.
being permissive about it.
Thank you.
Thank you.
All right, when you're ready.
Section 13 basically specifies to whom marijuana processing sites may conduct transfers. And again, that language might need to be changed to reflect the co-location language that we have discussed earlier. If there's going to be co-location, then we'll want to specify that grow sites that have designated patients or patients that have designated grow sites, transferences to them as well as to dispensaries will be allowed. Section 14 basically says that if you're a caregiver or a registry identification card holder or a patient, then that processing registration system, it's not going to apply to you with regard to any type of product for the caregiver and for the patients, the concentrates. That's section 14. Section 15 is the database section, and that's basically the section that directs health authority to develop the database for purposes of allowing information that's collected underneath the tracking light sections, basically to gather that information and keep and maintain it. There was a lot of discussion about sharing of the information. That's in subsection 2 on page 34 all the way through page 35. And what the subsection 2 basically does is it creates a hook where if OHA determines through an investigation or a complaint process that there's evidence of some sort of wrongdoing, then that information may be shared, as long as it's not personally identifiable information other than addresses. So that's the hook for sharing the information with law enforcement, is if there is actual evidence of some sort of wrongdoing.
Okay, so,
Yes, Representative Olson. And
okay,
then
thank you, Madam Chair.
Buckley. Yes.
I'm going to kind of just spin off of what Representative Helms said earlier about the word may
Great.
versus shall on here, and I honestly think since it's being, as Mark has described, only information is going to be revealed anyways, I honestly think that this should be a shall.
Okay. Thank you. Representative Buckley.
Yeah, thank you, Madam Chair. Can I just move back to section 14 just for a second, Mark? This is where I think there's been some confusion about a medical cannabinoid product processed by a registry identification card holder. It seems to be saying that it cannot be transferred, it can only be used for personal use and not be transferred other than the registry identification card holder. So please, if you just talk me through this and reassure me that I could actually, well, maybe not Representative Olson, but maybe Representative Wilson, that I could actually share a concentrate. I could share a concentrate with another card holder, because this seems to indicate I could only use it for my personal use.
The idea with how this is written, and it's going to juxtapose with Measure 91 a little bit in the home grow provisions under Measure 91, as well as the sharing provisions of Measure 91. In the Oregon Medical Marijuana Act, you have a card holder system. And different card holders, for instance, caregivers, they might have multiple upon multiple patients that they're caregivers for. Same thing with, whereas underneath the home grow provisions of 91, you don't have that situation. What you have is you have limited amounts that can be shared in the home.
Correct.
So what this language is getting at basically is for that card holder relationship, the production of these items, it has to be closely maintained, and that's the way it's written. So if you're making it for your patient, it has to be the end user of it. There's nothing to prevent somebody underneath the provisions of Measure 91 from sharing concentrates or edibles as well within the household. So what this is really trying to get at is the fact that we do have this card holder system, and underneath these provisions, the end user has to be that patient. But again, there's a slight juxtaposition with 91 there, where there will be other activities that, the sharing of products will be a little bit more permissible under 91 and will not be subject to criminal enforcement. So does that make sense, Representative Buckley?
Thank you, Milk. It does. It does, but this seems to, it seems like there'd be a conflict, though, because this says it cannot be transferred to any person other than the registry identification card holder. So my concern is that means even if under 91, sharing of products is okay, are we passing a statute saying that sharing of products is not going to be legal?
No, because you have to remember the hook for the Oregon Medical Marijuana Act is if you're in compliance with it, you are accepted from the criminal laws of this state. That's what the Oregon Medical Marijuana Act does. So if there is no criminal law that would otherwise prohibit the activity, then it's not going to affect that activity.
Gotcha. Thank you.
No.
Thank you.
It may be worth not calling it out in each of the various sections, but maybe having a section that does clarify that a card holder can in fact transfer product or items to another card holder if we get to the point we think that needs to be called out, just for clarity. But that's the intent, is that pretty much what they can do now, and specifically this section 14 is just trying to say that if you are providing or processing for a patient and your relationship is directly between them and you're not taking stuff and moving it into the dispensary, then you do not have to abide by all of the health and safety that you would if it was going in for general public purchase or consumption.
Thank you.
Senator Przanski's he's absolutely correct too, Representative Buckley. I should have pointed out that the read-in is Section 10 does not apply to, and Section 10 is the statute that requires you to register as a processor.
Right.
So
we have a question from Senator Cruz and then Senator Byer.
Okay.
Did you have one? Okay.
Senator Przanski, correct me if I'm wrong. The way I read this is I'm getting a product from the processor. The product that's being made for me by the processor can't go over there with it. He's got to go here. But once I have it, I can do a lateral to somebody else. So, the way I'm reading that, the prohibition is against the processor going someplace other than to the cardholder. Would that be correct?
I believe so. What I would say is that a processor that's actually with the intent of moving the product into general sell is going to be required to follow all of the guidelines that a processor has to do. There are individuals that are caregivers that may be processing for their patient.
Right.
And so that individual, if what they are processing goes back to their patient, that individual that's the caretaker does not have to comply with or have a processor's license.
Right.
And so we're realizing, I think, is that we're at a stage where we have processors who are now somewhat independently working to put product into dispensaries.
I understand that. But for the relationship, I'm processing for you. What I'm processing for you, I can't give to Senator Byer, but if I give it to you, you could give it to Senator Byer.
That is correct.
Yes.
If you were a processor potentially for 2 patients, then you would be able to do that as well. But that's correct.
Yeah.
As how the chain of flow would go.
Great. All right. So let's keep going.
We're past most of the policy choices that were made up to a certain point. A lot of the stuff that follows at this point forward until we get to the testing and labeling provisions is actually a lot of cleanup that we've been working on with regard to the dispensary statutes for a long time over the course of the summer. So Section 16 involves a lot of that cleanup. We worked on it in the summer, trying to clarify the dispensary statute and remove the stuff that has been very problematic for rulemaking, as well as trying to bring it up to date insofar as Measure 91 is passed. A lot of these changes are very technical in Section 16. Just flipping through to page 41, we start to get into new language again. Section 17 on page 41. That's the grandfather clause for if a school is established within 1,000 feet of a dispensary after the dispensary opens, then the dispensary may remain at its current location unless it loses its registration. So if it loses its registration, then that's a different matter. But as long as it keeps its registration, then it can remain at that location.
And we should call out again, because this is one of those areas where people were concerned as to some of the original drafts had that they would only be able to be there for like 1 or 2 more cycles of their license. That is not what this calls for. This will allow a business that has been allowed to start at a location, so long as they are still in compliance with all the rules of OHA and their license is not suspended or revoked, they will be able to stay there even if a school does in fact move within 1,000 feet. So it goes into perpetuity.
Section 18, again, tracking light language, and this might go back to Representative Helms' question on the shall versus may with regard to the reporting of information that is of the products that are coming in and out of a dispensary. If you flip the page to page 42 through 43, designation, assignment, and foreclosure. These are basically some repairs to the base statute where we had a problem with the way we wrote the dispensary statute in 2013. It called for a person responsible for a grow site, and that ended up being very limiting, for a dispensary. That ended up being very limiting for the dispensaries, where they were kind of locked into that person for a registration cycle. And so what we did is we amended all the statutes to make it clear that there could be multiple persons responsible. And then we wrote into the statute that if you want to assign the responsibility to somebody else, in other words, I'm going to no longer be responsible, but this other person is, then that would be okay as long as they meet the criteria for a person who can be responsible for a dispensary. And we did the same thing with designation. So if you want to designate somebody to be under you, so you have 2 people responsible for a dispensary or a processing site, then that can happen as well. The foreclosure statute was largely copied from Measure 91. Basically, if there's a secured party, and if the secured party meets the criteria for a person responsible for one of these sites, and they can come in and continue to operate the dispensary or the processing site if for some reason it closes down. Exemptions from criminal liability and affirmative defense. This language is largely lifted from 475-309, which is the current patient registration statute. We took it out of there and we just basically copied it into a new section of law because it seemed appropriate to create a new section of law to catch all the various actors in the Oregon Medical Marijuana Act who are going to be accepted from criminal liability. This goes back to a previous question that Buckley asked about how does this relate to 91. And again, OMMA, the primary function of it is if you are comporting with the Oregon Medical Marijuana Act, then you're going to be accepted from criminal activity. And so that's the hook. If there is no criminal activity, then obviously it's still not going to apply to you. So we clarified here basically patients, designated caregivers, of course, also patients who have applied for and have proof of written documentation, just as in the existing statute, persons responsible for or employed by marijuana grow sites, persons responsible for or employed by processing sites, and responsible for or employed by dispensaries. For processing sites and dispensaries, also written in a person who owns. So those people would be accepted from criminal activity. We try to basically capture everybody who might be involved in the process. The next major piece of the bill is page 46, general powers. Section 25 is civil penalty power for OHA to impose a civil penalty for non-compliance with the Oregon Medical Marijuana Act, and we did reduce that amount from the original number, which was $5,000, down to $500. Section 27, allowance to enter into agreements for implementation and enforcement. Section 28, general language relating to the ability for the various agencies that might be involved here to possess, seize, dispose of marijuana, usable marijuana, and all the different products for purposes of ensuring compliance with and enforcing the provisions. Exception from civil liability on page 47, section 29. Accepting from civil liability the state actors that are going to be involved in administering the act.
Once again, in those three sections, I do want to, I want to call out Department of Ag and see if there's, the less agencies we have involved, the better. We know that. So,
Thank you.
Just a thought to have. Okay.
I actually have a question too. So the exception from civil liability, that attaches to the to work that is consistent with this statute. It doesn't accept from civil liability some negligent or reckless or otherwise actionable kind of liability by government personnel that is not consistent with the scope of their duties under this statute, correct?
Co-Chair Leininger, you're correct. It is the exception applies to performance of or failure to perform duties required by ORS 475-300, 475-346. So there's a tie-in to the actual provisions of the Act. There has to be a statute or a rule adopted pursuant to a statute you can point to and say, I was acting under that particular provision.
Okay. Any other questions? Great.
So the general confidentiality section, and this only applies to this only incorporates the grow sites, processing sites, and dispensaries. We wanted to clarify that with the exception of personally identifiable information that the Oregon Health Authority collects and maintains for purposes of registering various people, it's confidential and not subject to public disclosure. So all that information they're collecting, it's personally identifiable. It's not going to be subject to public disclosure. And then we have also written in here that the surveillance system information is also not subject to public disclosure, even though it's not personally identifiable information. If you flip the page on page 49, sections 31 and 32. 31 is just clarifying that seeds are a propagant of nursery stock, but they're not subject to those two series of law that are directly related to the regulation of seeds by ag. So that's what section 31 is. And then 32 is preemption of local government power. What we did here is we used our boilerplate language for preemption, and we made it very clear that the preemption extends to both the regulation of activities underneath the Oregon Medical Marijuana Act as well as any taxation related to the related to products that are sold or transferred underneath the Oregon Medical Marijuana Act.
Yes,
So,
Representative Olson.
Madam Chair, I think this is going to be a problem right here, the preemption issue, because I think that there are still cities and counties that would like to still weigh in on this.
Section 33 may answer some of that, Representative Olson, because that's where it goes into what their rights are on regular.
Thank you. Senator Byer also has a comment on this.
Mark, how does this interact with local nuisance and zoning ordinances?
We're just about to get
If you look at,
next page.
yeah, if you look at subsection 2, this is standard boilerplate language, except as expressly authorized by the statutory laws of this state. So if there is a place in statute you can point to and say a city or a county can do this, then they'll be able to do it. And that is the next section. It's the time, place, and manner section. Section 33, we went ahead and we modified what was passed in 2014. I can't remember the bill number. Everybody else seems to remember. It was Section 2, Chapter 79, Oregon Laws 2014, where we wrote in that local governments had the ability to impose reasonable regulations on dispensaries. And we've kind of broadened that power a little bit, and we've incorporated into it the processing sites as well as the grow sites. So there will be reasonable regulations of those three things in different ways underneath this section.
What does reasonable regulation mean? Is there a definition somewhere?
It's a pretty, Senator Cruz, it's a pretty loose term. It is something that could become subject to litigation. You're correct.
So, just to follow up, I mean, so Mark, if say county commission just didn't want to have anything like that in the county, this opens up that door?
Representative Olson, when we wrote this, we tried to move away from other language that would also be subject to litigation, which would be standard time, place, manner language, which has its roots in the history of the free speech clause of the Oregon Constitution, and try to move it into an arena that was a little bit separate from that, since free speech is not actually a part of these operations like it is with strip clubs. Which is where some of that language originated. What we've tried to do here is we've tried to spell out what the reasonable limitations are. And since this is a big issue, I will go ahead and work my way through them. Reasonable limitations on the hours during which a dispensary may operate. That would, and the idea there, we can speak about the policy of only applying the reasonable hours limitation to dispensaries. Conditions on the manner in which dispensaries may transfer the products to patients and recipients. Those are both part of the existing law. They're just a little bit spelled out now using the new terminology. We did add in reasonable requirements related to the public's access to grow sites, processing sites, and dispensaries. Prior to writing this new section, that probably would have fallen underneath reasonable conditions on the operation of the dispensary. We felt here it was important enough to spell out that the public access piece should probably apply to all three as opposed to just the dispensary. And then finally, limitations on where these different sites may be located. We also spelled out that reasonable regulations does not include any ordinance that would prevent or significantly restrict one of these sites from being located in an area in which, under state law, they may properly be located with regard to zoning. So if a site may be located in an industrial zone, you can't basically impose a regulation that would effectively prohibit them from locating there at all.
Mr. Mayor, I have a question. So if under local law, commercial uses may not be conducted in residential zones, what does that mean for medical grow sites in residential zones?
Could you repeat the question, Cheryl?
If in my neighborhood, you're not allowed to have commercial activity, would would it be permissible for my local jurisdiction to say, in no event may a medical marijuana grow occur in that residential zone, notwithstanding language that we have in this bill that says urban residential may be, up to X number of plants. If you came in before 2015 and after 2015, then why?
Co-Chair Leininger, I would say that's a question where you're talking about competing laws, and there's two general rules of thumb when you're talking about competing laws. The last law passed trumps a previous law, and then a more specific law will also trump a more generally applicable law. So I would say that what you're referring to is a more generally applicable ordinance that would be preempted by the more specific state statute that speaks directly to the matter.
Okay. Representative Buckley and then Representative Helm.
Thank you, Madam Co-Chair. I think it's very important to point out that having the reasonable requirements on public access, I think it's very important for my district, for instance, where we have grow sites in various parts of Jackson County where the neighbors are disturbed by people coming and going from the grow sites at all hours of the day and night. This would give the city or county the ability to say, you can't have patients come visit you at midnight or at 12:15. It gives a tool there to try to address some of the concerns that have been raised.
Right. Good point. Representative Helm.
Thank you, Madam Co-Chair. It's more of a comment than a question. I'm a little worried that I hope that we can keep this as an area that we're willing to revisit, because I think as we move into the adult recreation use component of our work, we're going to be confronted with a separate set of time, manner, and place ideas for recreational marijuana dispensaries that are different, but in functionality, these stores are going to be identical. They're going to function almost identically. They're going to look identical. And I would just wanted to share with the committee, my city, Beaverton, anticipating this very issue, adopted an ordinance mostly to address the upcoming end of the moratorium for medical dispensaries. But in doing so, they adopted an ordinance that's going to apply equally in the same way to both rec and medical. They're not drawing a distinction. And I think that makes a lot of sense. So I hope we would keep this as an area that we're open to looking at harmonizing the way that we give guidance to the cities in particular about how we locate the dispensaries.
I think that's a great idea. Senator Cruz had a comment.
The way I read this, if a city or a county wanted to do an outright ban, they would be subject to litigation, potential, because that would be considered to be unreasonable, correct?
Medical? Yes.
Okay.
I think the other part on this is, keep in mind what we're going through is on the medical side as compared to the retail side. And both, clearly we've called out in this, and it has been the rule anyway, that you cannot have a dispensary in a residential area.
Right.
And then I would expect on a retail side for commercial rec, it's going to be falling under the same guidelines of for any commercial venture. And so some of the stuff I think we're talking about already has the framework for how it will work. And what we're basically calling out here is that the state is taking the position as to the medical marijuana program as to us having the duty, the authority to actually allow for individuals to have access to medicine within their local area without going through other extremes. And on the other side of the coin, that we ensure that no matter what and where they're located, and again, I would expect that you're not going to be seeing cities allowing for commercial processing, even if it's commercial medical processing in a residential area, but instead will be in some business district or industrial area. And that's, again, where they have the ability under the reasonable place, time, and manner to call those out.
Any more questions on this section? Representative Olson?
No, stay away from it.
Okay. All right.
There's a large section following this, a lot of pages that are devoted to updating language and making sure it's consistent in that. So I'm going to fast forward to page 59, where we depart the Oregon Medical Marijuana Act rewrite. And we move into two other sections of the amendment which handle two distinct, what we're trying to do is set up universal guidelines for both testing and labeling. A lot of this stuff, and again, we've already gone through these two provisions as different amendments in a different hearing. The language has been looked at by both the Department of Justice, industry, as well as advocates for the Oregon Medical Marijuana Act, and we incorporated as much language as possible from those different discussions into both the testing and the labeling sections. A lot of this stuff is boilerplate. What it does do is it establishes universal requirements for testing or a universal mechanism for testing, for both medical and recreational. It does allow for treating the products differently. And then the same thing with the labeling, where it's going to be a universal mechanism for the adoption of the rules. Probably the most important section for the testing to look at, and there was some discussion from the last draft where OHA was doing the accrediting and OLCC was doing the licensing. This draft moves the whole package into OHA to do both licensing and the accrediting in order to hopefully streamline the process. But probably the most important section to look at in the way of substantive provisions is Section 49, which is on page 63, which is what the rules that actually direct OHA to establish certain procedures for tracking different types of products, determining batch sizes, procedures for documenting and reporting. And again, it's a roadmap of what the legislature expects to see in the development of these different procedures. Procedures for disposing of samples, different procedures for testing usable marijuana and different types of products, and for different things, microbiological contaminants, pesticides, contaminants, other contaminants as the authority determines is necessary to protect public health and safety, etc. So it's a roadmap of what the legislature expects to see. That carries through all the way to page 64. We have written into the statute that OHA can distinguish between recreational and medical products in the way of testing, and that the cost of a procedure needs to be considered as part of the rulemaking process. We have kept that language. Real quickly, we did direct OHA to consult the Commission, the Oregon Liquor Control Commission, and the State Department of Agriculture in developing these procedures.
Before we go further, I do want to call out for the record on Section 46. This is a section that basically calls out that items that are going to be sold retail, they do in fact require the testing, as compared to, again, if someone is having something done for themselves, either on their own as a card holder or they have someone that's designated as a caregiver, those items would not have to be tested. And also, I think it's worth noting that Section 47 starts off as to the uniformity that Mark has described as to the labs and how they are going to have to be meeting a certain standard. And then Section 50, I think, is another one that we should call out again. This will be that, again, it states there that testing is not required for products that are the cardholder's use.
And again, if there are corrections to the processing site statute, there might have to be some follow-up corrections in some of these sections too, but they would be very minor. Packaging and labeling, which begins on page 67. Again, we're carrying all the definitions through. We're trying to be consistent with the definitions throughout the entire draft, and we're going to try to be consistent with them in Measure 91 as well.
Mr. Mayor, may I interrupt you?
Yes, Co-Chair.
I have a question about Section 51. I've gotten some questions from community members today about inspection. Specifically, some folks have asked if there is power to inspect, somebody's 6-plant grow at home. And my understanding is emphatically that's not intended here. Can you speak to the scope of OHA's inspection?
Section
authority?
51, Co-Chair Leininger, Section 51 gives OHA the authority to inspect a premises licensed under Section 47 of this 2015 Act. That is the actual premises of where the testing laboratory is going to be located. So,
Again, let's call that out, because I think I've heard the same thing, and I know that no one on this committee ever intended or intends that we'll have anyone going to someone's house to look at their grow, but it's licensed under that section. So unfortunately, I think some individuals in reading this did not track back to what was actually being covered here as compared to as broad as some people read it.
So Section 47, it is only the laboratories that are being licensed. It has nothing to do with any of the other provisions of OMMA or Measure 91.
Thank you.
Page 67 begins packaging and labeling. And again, a lot of boilerplate in here just to cover the regulatory basis about what can be handled and what OHA, to allow OHA to have the power to do this. And again, the primary section to look at is page 69, section 59. And again, OHA, in consultation with the Oregon Liquor Control Commission and the State Department of Agriculture, establishing minimum standards for packaging and labeling. And again, a lot of this language is in existing law. It's from the dispensary statute. We lifted it from that statute and we put it in here using the new terminology that we're carrying throughout the entire draft. There are a couple of changes from the previous committee hearing. I think that there was a comment about making sure that edibles aren't processed in a manner that's attractive to minors, and how that might be overly broad. For instance, we changed that language, are not packaged or presented in a manner that's attractive to minors. Try to get away from, just cookies, and instead cookies with bunnies painted on them. And again, the two things that we've added are under paragraph E on lines 29 through line 3 on page 70. As determined by necessary by authority, we're going to include by weight delta-9 tetrahydrocannabinol, delta-9 tetrahydrocannabinol acid, cannabidiol, and cannabidiolic acid. That should actually be delta-9 tetrahydrocannabidiolic acid. And then we're also going to make sure that the edibles have the information on them that you would expect to see with any food product. Again, these are only going to be products that are for mass distribution through dispensaries and retail locations. They're not going to be products that are underneath the home grow provisions or underneath the other card sharing provisions of the Oregon Medical Marijuana Act.
Representative Helm has a question.
Thank you, Madam Co-Chair. I'm not understanding how giving information by percentage of weight of the product tells the consumer very much about what they're getting. So maybe I'm missing something. We've talked in other contexts about milligrams of THC, for example, as representing a dose. So I want to make sure that the purchaser is getting information that they can actually use.
Co-Chair Leininger, Co-Chair Burdick, can I speak directly to that, having worked with you and Mr. Holmes on that issue?
Sure.
We worked with Mr. Holmes, industry expert, on that particular labeling piece. And my understanding is, he's not here tonight, my understanding is that to an informed consumer, that percentage by weight information will be like caloric information to a regular user, to a regular purchaser of a food product. where you should be able to look at that information, and if you're an informed consumer, you should be able to know exactly what the content of the edible or other product is and be able to know what its effects will be. So I am not an industry expert. So that's just me talking with, that's just me relaying information.
Very subjective.
Pardon?
I am baffled by that.
Representative Buckley.
It kind of just begs the question, for the informed consumer, that's good information. How about for the low information consumer? We had talked about THC and other things. Is this information going to, in any way, help inform the kind of non-informed consumer? I mean, or is there anything on the packaging that will help the non-informed consumer make a judgment on the potency of the product that's going to be consumed?
Co-Chair Leininger, Co-Chair Burdick, Representative Buckley, absent a general warning that the product might get you high, I don't think that we could actually achieve that. Because I think if you get to milligrams or any other way of denoting what's in the product, I mean, it's just something for you guys to consider policy-wise. There's going to be a gap between knowledge and what the product contains.
Now, there was some testimony that we previously heard from Anthony Taylor regarding some products, I believe, out of Colorado that actually may have had some type of scoring as to, and I forget exactly what it was. We may want to look at that. I forget, it's like 1 through 5 or something that they've come up with that might be something that's more for the lay person as to getting that information to them.
And then my understanding is that this is essentially a floor, not a ceiling, in terms of information the OHA can provide, and we're trying to steer clear of, completely prescribing their power to do this, but identify some parameters. So it may evolve, like some other aspects. It may evolve as we work through implementation.
Chair Leininger, that is correct.
Yes, sir.
Yeah. I remember seeing on a couple of these products out of Colorado and other places that users of the product are warned about partaking too quickly. People trying a chunk and sitting around for 30 minutes and saying, well, that didn't work, so let's try another one. And so it seems to me that I have seen some language on some of the wrappers warning people not to take it too quickly. Am I right? Have we seen that?
We have.
I was thinking we had seen that.
We have.
It seemed like that might be appropriate.
But again, Representative Wilson, I think what we're looking at, instead of trying to, let's say, micromanage and put everything into the statute, we want the flexibility. I would surely expect that the rulemaking process will, in fact, include that.
Good. Okay.
Through the rulemaking. And that way, I think they'll be able to hone in specifically as to the language that should be included besides, because we are giving that broad authority
Yeah, okay.
to do that.
That's good.
Great. All right.
So the remainder of the amendment is conforming amendments, with the exception of the miscellaneous sections at the end of the bill relating to repeals, operative dates, and that sort of thing. Again, Section 70 on page 88, the operative date for the bill is March 1st, 2016. And everything is going to become operative on that date. That's the date by which we're telling OHA to be ready with these programs. We give them the standard ability to go ahead and start implementing immediately upon passage, and there is an emergency clause. So hopefully I didn't skip anything.
Let's see, Representative Buckley and then Senator Cruz, please.
Thank you, Madam Co-Chair. Thank you, Mark, for the explanation. The two areas of the bill that we didn't really talk very much about, the reporting section and then the residency requirement. I don't think we had much discussion of that. If I can go take the residency first. Mark, just to clarify, is there anything in the bill that would require someone to be a 4-year resident of the state before getting a medical marijuana card as a patient?
No, Representative Buckley. There's no 4-year residency requirement for patients. The bill merely requires patients to prove residency.
But if I can follow,
Yes,
but if you were to want to become a grower for the medical marijuana program and you are not currently a grower as of January 1st, 2015, would there be a residency requirement?
So prior to January 1, 2015, there is a residency requirement that you have to prove residency for a year if you registered before that date, before the effective date of Measure 91. After the effective date of Measure 91, January 1, 2015, you would have to prove a 4-year residency requirement. That's the way that the bill is currently written. For people who are concerned about, well, I'm not a resident, I haven't been a resident for a year now and I've already registered, you have to remember that the operative date is March 1st, 2016, so by the time we get around to the that time, you should be able to prove your 1-year residency.
Gotcha. And if I do you want
Yes,
to go
please.
on the reporting section too. On the reporting section, for a grower to report, it's hard to actually try to, I don't know what more we can do prior to rulemaking, but at least it's my perspective on this. The reporting could be every month reporting could be as simple as a simple either one-page document that goes over the internet that says name of grower, location of grow site, number of patients, number of plants. That's your report, period. You send it in. After a harvest, you'd be saying, we've harvested these plants, we have these plants still growing, this part of the harvest is in process, and we've dried and weighed this part of our. So we're not trying to set up a onerous system of reporting, but we're trying to set up a system that a grower would be able simply to keep in touch with OHA on how many plants they're growing and the distribution of the harvest. It's that, and maybe I aim that towards Senator Brzezinski to confirm that's the intent of the legislation, is a simple report, not an onerous multi-page document, and we're trying to keep it as simple as possible.
That's correct, and we also took in consideration as to what would be simplistic for both indoor and outdoor growing, and we came up with the conclusion that instead of having it set up like quarterly and then monthly based on when you get to harvest, to run it on a monthly basis so it's uniform, systematic. And as you said, I would expect you take a grower who's growing on the outdoors. The vast majority of the time, they'll probably be putting in zero activity onto their farm because they're not actually going to be up and running until their growing season, as compared to if you have an indoor grow operation that's having production of a product every 3 to 4 times per year. You will see a more systematic reporting of what they're doing with the product, where it's going, what patients are, in the sense of what they're delivering back, because there is that tracking that's required. And that's the other part I think that's important for the processor, knowing this was going to be a new component within this process to ensure that there was the accountability. But again, by keeping it as a light reporting as compared to a seed to sell that we're anticipating will be in the recreational side, you'll still have the ability to confirm and hold people accountable for their conduct.
Thanks, sir. Thank you, Madam Chair.
Yes, sir.
Madam Chair.
Senator Cruz had a question, and then Co-Chair Burdick, please.
Madam Co-Chair, not really a question. I just wanted to thank Mr. Mayor for his work. Our paths have crossed many times this session so far, and he does outstanding work. So, Mark, thank you for all the effort you put into this, although you're not done yet. So.
Yeah, sounds like it. Thank you, Senator Cruz.
Co-Chair Burdick.
Well, I want to first of all echo that. Thank you very much for saying that, Senator Cruz. You've really worked hard. I remember one time we got a draft at 4 o'clock in the morning from Mr. Mayor. On the reporting, it is a reporting light, but I just wanted to note that there are penalties. You could lose your growing license if you don't tell the truth on your report. So it's not an onerous requirement, but there are consequences if you don't abide by them, because what we're really looking for is accountability and make sure that the marijuana goes into legal channels.
That's wonderful. So does yes, sir.
I do. Okay.
Representative Olson.
Can we go back, Senator Brzezinski and Mark, because I'm trying to get a handle on what I asked earlier, and then, Senator Brzezinski, you alluded to a second,
And where are
different
we at?
portion. So I'm on page 49. So it would be the preemption part or the opt-out part. I'm reading this, and I get where you referred then to the one portion on page 50, the reasonable regulations. And I also heard you say that a city or county could ban a dispensary if they wanted, but it'd be subject to litigation. I did hear you say that.
No, actually, Senator Cruz said that, and I confirmed that if a city wants to challenge the state's ability to preempt them, clearly there could be a lawsuit filed.
Okay, so then I guess my question would be to just hone in on a little bit. We will not be like what Colorado or Washington has been and not allow an opt-out? I mean, it's my understanding they're both having opt-outs right now.
Well, co-chairs and Representative Olson, we're talking about the medical program as compared to the recreational program. And the perspective that the drafters of the measure that was put before the voters in 1998 was not to allow for an opt-out on the medical program. We treat medicine as medicine and not allow for the distinction of a city or a county to say we're not going to allow our citizens to have access to medicine that is allowed and permitted under state law. Regarding the recreational part, there's another scenario there as to how that would play out, and that, to me, is two different creatures to be addressed. And if you remember, if you want to get back to when 3460, if I remember correctly, the number passed and we established dispensaries, it was the intent of the two co-chief sponsors, myself and Representative Buckley, that we were going to allow for those entities to exist in a city or in a county to allow for patients to have access. We entered into an agreement that was became law that allowed for a moratorium until May 1 of this year, with the understanding, at least on my part, when I shook everyone's hands, that at that point the cities would have had the time and the counties would have had the time to absorb their concerns and move forward in allowing for access of medicine to their patients in their geographic areas. And so it's still my position that we should in fact outright preempt the cities and the counties from being able to outright prohibit dispensaries from being within their geographic boundaries.
Okay. Of what I know of the, Madam Chair,
Yes.
Okay. I don't believe in 1998 we had dispensaries identified in that. That didn't happen until, what, 3460?
Correct.
Right.
We did not.
Right.
It specifically was chosen not to have dispensaries because of the state of the law as to what was happening in California, and it was determined by the drafters of that measure that we would not permit that.
Okay, I just want to point out here that especially under Section 33, the reasonable regulations, and it goes through the whole list there. It's boxing in the cities and the counties.
So, Madam Co-Chairs and Representative Olson, can you please, I guess from my perspective, what other medicine has the state allowed the city or county to prohibit an individual to access in their geographic boundaries?
Well, okay, so we're just going to describe it that way. I'm thinking you're calling it medicine. I still haven't heard the federal government call it medicine yet. That's the thing.
No.
That's
why we have state rights.
I agree with. I've seen some clear evidence that it works. But
yeah. Well, at least we have rescheduled it for state purposes as a Schedule 2 because of the benefits that our state has determined through the vote of the people that this is what they consider, and so feel that we should honor it.
Thank you.
Thank you.
All right. Any other comments as we talk through the bill as it is drafted? Our expectation, if we wrap things up a little early, is that on Wednesday we come back and we will have more work session time on this bill. We've identified some good elements in our conversation in the last hour and a half for potential tweaks. of language that could be reflected in a subsequent bill or in some other manner. But I think that there's a lot that I think is right on track in this, and I want to echo comments I've heard about the great work that you've done. The Department of Justice has been a tremendous ally. I want to thank Shannon O'Fallon and the Attorney General for generously allowing you to provide a lot of good insight into this process, and everyone on this team who's been working hard on this bill. It's not easy. Not everyone is going to be on exactly the same page, but I think we've sure come together from very, very different starting places over the course of the last couple months to be at a place that I think is quite reasonable, and I would never expect it to be exactly here. But based on all we've learned, I think there's a lot of good work in this that makes sense. Representative Wilson.
Yeah, thanks, Madam Co-Chair. I agree. I appreciate all the great work. I just wanted to mention I had 350 emails come into my office today and 60 phone calls suggesting tweaks.
Representative Buckley.
Thank you, Madam Co-Chair. To work off that statement from my colleague, I've really appreciated the emails that have had specific parts of the bill they've questioned, but it helped me ask questions tonight in regard to try to clarify, for instance, the residency requirement does not apply to patients, things like that. So for folks in the next, a couple days that are going through this and have concerns about the bill, I would really appreciate those comments coming in via email that have a specific part of the bill that you have concerns and comments on that we can try to address, rather than just a kind of you're trying to take medicine away from patients. Because I can tell you flat out, there's not a single person on this panel that wants to take medicine away from patients. So that's never the intent of this. The intent is to try to find the balance I referred to earlier. Thank you, Madam Co-Chair.
Thank you. Senator Ferrioli has a comment, and then Senator Burdick, it looks like you have a comment.
Actually, it's a question for the co-chairs. I guess I'm inferring from the commentary that you will not be revisiting public testimony on the -6 amendments.
Yeah. Madam Chair, if I
Yes,
can respond
please.
to that. We've had hearings on every element of this bill. Everything has been vetted, has been heard. And I just wanted to point out, we have the fiscal impact statement. Is going to be complicated on this bill. It's going to take a few days. That's why we can't do anything with it tonight. We expect to have the fiscal impact done by Wednesday, at which point I anticipate having a vote. As we said before, the tweaks, if we find tweaks in here, technical matters, we can address them in the subsequent bill, and I think the land use issue is a very good example of that. I have asked Mark, our long-suffering drafter here, if it would be possible to get an amendment clarifying this, the work group's intent, and I think the intent of both bills, that that counties as well as cities have time, place, and manner authority over marijuana operations within their counties. The way it's drafted, they have that authority for dispensaries and processors, but it was left out of the growing operations, and it was certainly our intent as we struggled through this bill to have it apply to those. But with that limited exception, because you assured me that we could get it done quickly without a fiscal impact, and it's really important because we are running out of time. Our job, the job that we were actually hired to do, which is implementing 91, has not begun yet, and it's time to begin it. So we will have a vote on Wednesday. It's been a great discussion. Everyone on this committee, every single individual, has worked hard on specific areas of this legislation. We've had work groups. We've had individuals stepping forward with their expertise. Senator Przansky and Senator Buckley, Representative Buckley, there you go, getting promoted again, with their expertise with the previous dispensary bill has been invaluable, and it's been a good process. It will be good to have this part of it completed so that we can get on with our main job, which is implementing recreational marijuana.
Senator Przansky has a comment.
Yeah, Madam Co-Chairs, for both of you, I hope that you would allow Mark, if he can take some of these other ones. There's some very minor stuff here that I just think we can put to bed by getting it into this amendment, or if it's a -7, whatever, and have it done. It's not going to have an impact, but it will get it off the table, and those who are here will actually know that we've actually addressed and heard some of those concerns to ensure we're going to have more smooth sailing when we get into the recreational side on 91.
We will leave that up to Mr. Mayor if we can get it done by by Wednesday. I'm sure we can. He assured me that we can get this one piece done by Wednesday. If we can get the other technical tweets that we identified done by then, that's fine. But if it's going to hold it up, they're going to have to wait.
So Senator Burdick, Representative Langinger, the way to do this, it's not something that our office does very often, and you probably have not seen it. I know Representative Greenlick has seen it because he did it for both modernization of public health this year as well as House Bill 2009 and 2009. And those are the only two times we've done it in the past, I think, 15 years. But we can write an amendment to an amendment. And so that's how I would handle it. And if I get the go-ahead on what the exact things are that need to be repaired, I have a short list. Let me know what those things are, and I will be able to prepare that. And from what I've seen, it could be a very short amendment to an amendment that should be able to be processed very quickly.
It would be quicker.
Pardon me, sir?
That would be quicker than having to do rewrite. So.
Yeah, correct. The committee would have to adopt the -6s, of course, and then adopt the amendment, the -7s, which would be amending the -6s.
Right.
So in recognition of that good suggestion, I suggest that we get to Adam by 9 a.m. tomorrow morning. Any very small technical wording changes that you think that we talked through and there was agreement to, and then the two of us can take a look at them and make sure that they won't hold up the fiscal, and we can get those to you tomorrow morning so that we can move that forward with an understanding that there are some issues, including things like zoning, that we'll need to think through a bit more and may visit in the Measure 91 package.
And just an admonishment to their advice to the committee, they really do need to be technical, because if there is any controversy over the -7s, they will not be adopted, and we will have to wait until the next iteration, because we are getting this bill out Wednesday. Thank you, Madam Chair.
Thank you. It's so good to work with her. What a great group. Thank you, everybody. Thank you, everyone who's been here today for the last few weeks. And we're at an important turning point. And for now, the Measure 91 committee is adjourned.